The Honorable presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good afternoon. Welcome to the North Carolina Court of Appeals. I'm Judge Valerie Zachary. Serving with me on this panel are Judge Phil Berger and Judge Chris Brook. Assisting us today are our Clerk of the Court of Appeals, Dan Horn, and the Supreme Court Director of IT, Fred Wood. Pursuant to the directives of the Chief Justice, we are live streaming this session of the court as we work remotely during the COVID-19 pandemic. Although we cannot currently invite members of the public to our courtroom in Raleigh, we are happy to welcome everyone to our virtual courtroom in the spirit of our tradition of publicly held proceedings. On the calendar this afternoon, we have the case of McDowell versus Buchman from Wake County. If counsel is ready, let's proceed. Each of you will have 30 minutes for your argument, and of course, appellant will argue first. Ms. Lindell, I know you've reserved 5 minutes for rebuttal.
That's correct, Your Honor.
Please proceed.
Thank you, Your Honors. May it please the court. My name is Becky Lindahl, and with my colleague, Michaela Holcomb, we represent the appellant, Ms. Joanne McDowell. As a preliminary matter, before I begin my argument, Your Honors, there was a motion to strike our reply brief that was assigned to this panel. And during the practice session, Mr. Russell and I agreed that if the appellant, Ms. McDowell, agreed, as we noted in our response to the motion, that we would, to voluntarily remove footnote 2 on page 7 of our reply, that the appellee would withdraw his motion to strike. So the motion to strike has been voluntarily resolved between the parties, if that is acceptable to Your Honors, and we will not ask to be heard on that motion today.
Thank you. Mr. Russell, can you confirm that, please, for the court?
Yes, Your Honor. We did reach that agreement during the practice session, and we will withdraw that motion.
Thank you very much.
Thank you. Your Honors, although the content of the orders that were before the trial court to be registered are emotionally charged and involve complicated issues of child custody, the issue before this court today is quite narrow and procedural. The issue is a 7-year-old emergency custody order a proceeding that has commenced as defined under the UCC-JEA that required Canada to decline to exercise jurisdiction over a motion to modify child custody?
Ms. Lindell, I have a question. Are there any circumstances in which an ex parte order can be a final order in a custody case? Your Honor, the case that is most instructive on that question is Woodring versus Woodring, which both of the parties cite in their brief. All of the cases that deal with the issue of whether a temporary order can ever become a permanent order. Excuse me, Ms. Lindell, isn't a temporary order different from an ex parte order? You know, you have an ex parte order where one party is not represented and may not even have noticed that the other party is approaching the judge about getting an emergency order, and then you then from there proceed to a temporary order. So is Woodring really addressing an ex parte order, or is it addressing a temporary order? Woodring was addressing a temporary order versus an ex parte order, Your Honor, and I am not aware of any North Carolina cases that answer Your Honor's question directly on point. The closest case would be Campen versus Featherstone, 150 NC App 692 from 2002, and that case was cited for the rule, the proposition that ex parte orders are temporary orders. Which is where we get into the body of law that addresses the difference between a temporary order and a permanent order.
And that concept is discussed extensively in the Woodring case that both parties rely upon with different conclusions. But Woodring addresses the idea of whether a temporary order can become a permanent order by the passage of time. And that highlights the reason why the circumstances of this case, and indeed the circumstances of all of the cases in which the Court of Appeals evaluated the question of can a temporary order become permanent by the passage of time, are fact-specific, and they depend upon the facts of each case.
Well, and Ms. Lindahl, I apologize. Let me sort of pick up there with this fact-specific nature. Let's assume that parent A gets served with an emergency custody order that has the same terms and conditions as the order in this case. Parent B in the hypothetical is actually served with the ex parte order. How would parent B go about getting visitation or setting a visitation schedule after being served with an emergency custody order identical to the one in this case?
Your Honor, a visitation schedule could be established upon a further hearing of the court. And that would, ideally, an order setting, establishing ex parte custody, or excuse me, establishing custody on an ex parte basis, would also have a specific return date for the parties to come back to the court and have a full hearing on visitation. The order here did not have a definite and specific return date, which is one of the hallmarks that the North Carolina appellate courts have found distinguishes between temporary and permanent orders.
Can an ex parte order ever not contemplate a future hearing on the merits? Can a valid ex parte order ever not contemplate that?
Your Honor, there is no case law that I'm aware of that addresses that specific question. The important question here is not whether this order was valid with respect to the principles of North Carolina child custody law, such that we would know with certainty what standard to apply if Ms. McDowell were to attempt to modify this order. This is a question under the UCCJEA of whether an emergency order that has been pending, or that it was entered 7 years ago with no action to enforce it, would still count as a proceeding that has commenced under the UCCJEA. Our legal research, excuse me.
To pick up Judge Zachary's question there for a second in your response to it, you note that there's not a date that's being set by this order, but looking on record page 20, and pointed out by opposing counsel in the briefing, it is part of the decretal portion of the order says pending a hearing in this cause on the merits, right? So while it doesn't set a date, it does countenance that there are going to be further hearings, in this instance, hearing on the merits in this case, right?
I apologize, Your Honor. I had a little bit of difficulty hearing you, but I believe I understand the question, which was how does Ms. McDowell deal with the language in the order that says pending a hearing on the merits?
Yeah, basically in response to your point that there's not a date certain that we're going to have a hearing on the merits, but there is in the order countenance that we're going to have further hearings, right?
Your Honor, the cases that talk about whether a hearing is temporary or permanent do contemplate an actual date included in the order. And here, perhaps under different circumstances, this order could be construed as temporary if, for example, a hearing actually had been conducted within a reasonable period of time. But this order was entered over 7 years ago, and there's been no effort whatsoever to enforce this order. And so the passage of time here is a fact circumstance that allows this court to hold that this order, although it may have been temporary at the time it was entered, has converted to a permanent order by the passage of time. And again,
well, Ms. Lindell, so again, you mentioned facts. What fact or event terminated or stayed the North Carolina proceeding?
Your Honor, the court has not entered any writings or anything in the court file that has terminated or stayed this proceeding. The facts that would allow this court to issue the narrow holding of whether this order whether this order constitutes a proceeding that has commenced under the UCCJEA are that the appellant mother moved to Canada in 2013 and consistently resided in Canada with the minor child until 2015. At that time, after 2 years had passed, the appellant mother filed filed a petition with the Canadian court to modify child custody and served all pleadings in that proceeding on the appellant father. The UCCJEA explicitly provides that home state jurisdiction of a child doesn't change until the child has continuously resided within the new state, and the parties agree that Canada is a state under the UCCJEA. The child has to have resided within the new state for 6 months. So that 6 months provides some protection to the parent who has not moved to go back to the court where a proceeding may have been pending and ask for relief in that court. And that never happened here. Dr. Buchman was, it's undisputed that Dr. Buchman received actual notice of the proceedings in Canada. He was served on at least 4 separate occasions, and we know that he was actually served and actually did receive those pleadings because the record reflects through the affidavit of Ms. McDowell's attorney that was submitted to the trial court here. The record reflects that he hired counsel, Canadian counsel, on 2 separate occasions, and that those attorneys in Canada contacted Ms. McDowell's attorney, made at least some preliminary indication that they would be representing Dr. Buchman in the Canadian proceeding, and then within a short amount of time notified Ms. McDowell's attorney in Canada that they actually were not representing Dr. Buchman. So Dr. Buchman...
Ms. Lindell, I'm sorry, excuse me. Didn't Ms. McDowell represent to the Canadian court that there was a permanent order in Henderson County?
Your Honor, I'm not familiar with whether she used the word permanent. I believe, yes, Your Honor, I believe that the Canadian court proceeded with the understanding that the order was final in Henderson County.
Did the Canadian court assert emergency jurisdiction under the UCCJEA?
No, Your Honor, it is not our position that the Canadian court asserted emergency jurisdiction under the UCCJEA. Rather, the Canadian court determined that North Carolina no longer had continuing exclusive jurisdiction because Dr. Buchman has never lived in North Carolina. That's a fact that's not in dispute. And Ms. McDowell and the minor child have lived in Toronto continuously since 2013. So the Canadian court...
But isn't that the rule only if there's a final order in Henderson County? If there's a pending case, that's not the rule, is it?
Well, that's precisely the issue, but we would characterize it just slightly differently. The question is whether there is a proceeding that has commenced under the UCCJEA. So although the characterizations of custody orders in North Carolina as temporary or permanent, which are made for those designations are made for the purposes of directing the trial court to the appropriate standard to modify child custody. Those cases are helpful analogs for us and for the court to look at to determine whether there was a proceeding that had commenced under the UCCJEA. But the precise question of whether an order like the one before your honors counts as a proceeding that has commenced under the UCCJEA, at least to our legal research, has not squarely been addressed by the North Carolina appellate courts. And in fact, there's a helpful Woodring by its language. Woodring was not a UCCJEA case, but Woodring does note at page 642 of the opinion, and the site for Woodring versus Woodring is 227 NC App 638. It's from 2013. And at page 642 of the opinion, the court notes that it has determined whether a custody order is temporary or permanent in two situations. One is an interlocutory, whether the party has an immediate right to appeal, so whether an order is interlocutory, and two is the standard that a trial court applies in a custody determination. So Woodring, although it is useful to help guide the court on whether a custody order that is designated as temporary by the court can be converted to a permanent order by operation of time, it doesn't squarely address the UCCJEA issue. That, to our knowledge, is an issue of first impression for North Carolina's appellate courts.
But part of my understanding of opposing counsel's argument is that Woodring stands for the concept that, yes, the passage of time can, in certain circumstances, impact whether an order that is temporary originally becomes permanent. But it seems to, at least I understand opposing counsel's argument to be that there's sort of a categorical carve-out in this language where it says a temporary custody order that does not set an ongoing visitation schedule cannot become permanent by the operation of time. So yes, the operation of time is pertinent in general, but if the visitation order is not, if the visitation schedule is not established, then the passage of time actually doesn't help you here to establish that you have a final order. That's what I understand opposing counsel's argument to be. What's your response?
Yes, Your Honor, that's my understanding of opposing counsel's argument as well. And my answer to that is that Woodring has, by its own language, limited itself to interlocutory appeals and the standard that a trial court applies in a custody determination. And Woodring explains that that an order that does not establish visitation cannot become permanent because of the important right of a parent to exercise or have visitation with their child. And so the issue there is, if you have an order that has been deemed temporary by the trial court and a parent wants to modify that order, they only have to show that the modification is in the best interest of the child. Whereas if there is an order that was temporary, so when it was temporary, the standard was best interest, but if it becomes a permanent order by operation of time, then the parent has to show both changed circumstances and then go to the best interest of the child analysis. So Woodring can be read to explain that for the purposes of modifying child custody in an instance where North Carolina has continuing exclusive jurisdiction over child custody, the standard, the evidentiary and proof standard for a parent can't be changed by the passage of time. But that's not what we're asking for here. Here, the ability to participate in, or the applicable standard for child custody, isn't implicated by Canada exercising jurisdiction. Dr. Buchman still was able to go to Canada and make whatever argument he wanted, and he chose not to do so. So we would urge the court to find that Woodring is not inconsistent with the position that we're taking in this appeal, that for the purposes of the UCCJEA, a temporary order that is never enforced for a period of 7 years can be found not to be a proceeding that has commenced under the UCCJEA, such that the new home state can modify custody. Your Honors, the parties agree that there's essentially two paths that the court could have taken, that the trial court could have taken. If the order was part of a proceeding that has commenced under the UCCJEA, then the trial court should have gone to Section 206 of the UCCJEA. But if it was not, then it would go to 203, and the court need only determine that Canada has jurisdiction or would have had jurisdiction to decide child custody in the first instance. And here, it's indisputed that it's not disputed that Canada would have had jurisdiction under 201A1 because it was the home state of the minor child on the date of the commencement of the Canadian proceeding, which was April 2015. And the minor child had lived in Canada at that point for almost 2.5 years. One issue that has been raised in the appellant's brief is whether the Canadian action was simply a re-litigation of the North Carolina action, and it wasn't. The appellant mother, as is set forth in the record in the order that was entered by the Canadian court, the appellant mother moved to Canada. I understand the parties have a disagreement about what word should be used with respect to whether she moved or relocated, but we can all agree she went to Canada. And she did so out of fear of abuse of her child. And although there were issues raised at the trial court in the 4-day trial that resulted in the first custody order related to that abuse, there's also evidence in the record that after the first weekend visitation that Ms. McDowell identified further child abuse and moved to Canada following that visitation. In the Canadian petition, and this is set forth in the order that was attached both to Ms. McDowell's petition, but also to the affidavit of her attorney that was submitted to the trial court, the trial court noted that there were several circumstances that warranted a change in custody from the Henderson County order. The first was, and this is in page 27 of the record, but the first is that the child had been living in Toronto at that point since December of 2012, which is nearly 3 years. He had no contact of any kind with his father since living in Toronto, and he was receiving medical care, medical care and treatment, and his education and well-being were well attended to by service providers in the Greater Toronto area. So those are circumstances that were not present at the court, at the North Carolina trial court when the initial custody order was entered. Ms. McDowell's burden to register this foreign order is set forth in Section 305 of the UCCJEA. And it requires her only to submit a petition. It's essentially it is an AOC court form, which counts as the document requesting registration, as well as 2 copies, one certified of the determination that sought to be registered, and a statement under penalty of perjury that order has not been modified, and then the name and address of the interested parties. And Ms. McDowell met her burden. In response, Dr. Buchman challenged the jurisdiction of the Canadian court, initially also challenged that he had received service, although it appears from the transcript and also from his appellate briefing as if that argument has been abandoned. And as part of his challenge to the jurisdiction of the Canadian court, he passed up to the court an unsigned copy of a Hague application. There is no signed copy of that Hague application, but it's important to note that Dr. Buchman, in his submission to the court, characterized the order that is at issue here, the January 31st Henderson County order, as a final order, and he submitted that to the trial court. That is evidence that this court should consider when making a determination of whether the Henderson County order is temporary or permanent. And there's case law.
Excuse me, Ms. Lindahl, was that admitted into evidence?
Your Honor, it was not admitted.
The unsigned application?
Your Honor, there's no indication, I was not trial counsel, but there's no indication in the transcript that it was moved into evidence or admitted into evidence, but it was passed up to the judge, and it was argued, the Hague application was argued by counsel. We would contend that that Hague application is an admission by Dr. Buchman, a non-hearsay admission by a party opponent under 801D of the Rules of Evidence. And there's case law in North Carolina that indicates that a party's position before the trial court is some indication that position should be accepted. And that case, that comes to us from Peters versus Pennington, 210 NC App 1 from 2011. In that case, there were many motions and orders related to child custody, and an issue on appeal was whether a particular order modified a custody order and whether that order that was modified was permanent or temporary. And in that opinion, the court found that the mother's argument that an order was permanent was undermined by her litigation posture at trial, in which she stated that there had been no prior custody proceedings concerning the minor children in the courts of this jurisdiction or any other jurisdiction. And the court explained there that that litigant was not permitted to swap horses on appeal to obtain a better amount. And we certainly think that that is applicable here. I am cutting into to Ms. Holcomb's rebuttal time. So unless your honors have further questions, I will stop for now and save the remainder of the time for Ms. Holcomb. And would your honors like to hear from her on Section 208 now, or wait for rebuttal?
It's fine to wait for rebuttal. I think that'll be fine. Judge Berger, do you have any further questions?
No, thank you.
Judge Brooks?
No, thank you.
Okay.
Thank you, Your Honor.
Thank you. Mr. Russell, you may proceed.
Judge Zachary, Judge Berger, Judge Brooke, thank you for taking the time to hear this case today. May it please the court, I'm Jeff Russell with Darrington Smith here in Raleigh, and I'm here today on behalf of the defendant appellee, Dr. Stephen Buchman. We're asking this honorable court to affirm the ruling of the trial court, which correctly denied registration in North Carolina of a foreign custody order, which was not entered in compliance with the UCCJEA. The trial court ruled correctly in this matter for three principal reasons. First, Canada lacked jurisdiction to enter the order because there was already a pending action in North Carolina. Second, Canada should have declined to exercise jurisdiction in the matter because of plaintiff mother's unjustifiable conduct in abducting the party's child and absconding to Canada. And finally, no other provision in the UCCJEA, including temporary emergency jurisdiction, allows Canada to exercise jurisdiction in the way that it did. And at the outset, Your Honors, I would note that Ms. McDowell's counsel often claims that she moved or relocated to Canada. She didn't move. She absconded with the minor child to Canada. Nowhere in the record does it reflect that she informed Dr. Buchman that she was moving. And quite frankly, there's a term for moving out of the country without telling the father of your child where you're going. It's not relocating and it's not moving. It's felony child abduction. That's exactly what Henderson County has indicted Ms. Buchman with. And just recently, Your Honors, she's tried unsuccessfully to do away with that indictment in this court. You can look at COA 1911-42, where she appealed to this court the denial of her motion to dismiss the Henderson County indictment. And because she's never shown up in Henderson County to plead guilty or plead not guilty, or even be served with the indictment, her appeal was deemed interlocutory, and this court granted the state's motion to dismiss her appeal in February. So the idea that she moved or relocated to Canada is something that we would dispute pretty heavily. I think it's important to understand that Ms. Buchman from the beginning, Ms. McDowell from the beginning has tried to keep Dr. Buchman from exercising any visitation. If you look at the record, particularly the order that was entered in 2012, the order recites that basically the first year of the child's life, Dr. Buchman didn't exercise any visitation. Finally, a consent order was entered in March of 2011, and he exercised some limited visitation from April to July. But then Ms. Ms. McDowell filed a ex parte emergency custody order in September of 2011, which was finally dissolved in November of 2011 because it properly had a return hearing on that motion. And the court found that there was no emergency. She didn't prove her case there. And then visitation resumed briefly, but in February of 2012, she began interfering with Dr. Buchman's custodial time again by requiring that she supervise those visits. And she prevented him from seeing the child right up until a custody hearing on his motion to modify the previous order that was heard in October of 2012. That motion was heard over 4 days in October and November. Ms. McDowell presented evidence that she believed that the child had been drugged or sedated in Dr. Buchman's care. And however, the record reflects that there was a drug screen that was done that came back negative, and the child was seen by its psychologist and its pediatrician within minutes of the custody exchange, and neither found the child to be abnormal. So then Ms. McDowell begins claiming that the child might have been sexually molested by Dr. Buchman, but according to the record, presented no evidence to substantiate that claim. Quite the contrary, the trial court found that the minor child was well adjusted to each parent, and that it was in the best interest of the child to have a meaningful relationship with both of his parents. And it was unnecessary for Dr. Buchman's visitation to be supervised. And so the trial court entered an order on November 7th, 2012, which gave primary custody to Ms. McDowell, but gave some makeup time to Dr. Buchman in December of 2012. And then with the idea that he would begin exercising every third week of custody beginning in January 2013. However, he never got to do that because Ms. McDowell went to Canada with the minor child. And so when Ms. McDowell ceased to communicate with Dr. Buchman about the child, he filed for contempt and filed a motion for emergency custody, which the Henderson County Court entered ex parte and found that McDowell had removed the child from the jury. Important there, Your Honor, is that that order awarded Dr. Buchman sole custody of the minor child pending a return hearing on the merits. And that's a return hearing that to this day has never happened. It's only after hiding in Canada for over 2 years that Ms. McDowell filed an application to Canadian court to have an urgent interim motion heard. And apparently, according to Ms. McDowell's trial counsel, that urgent motion was because Dr. Buchman was filing a Hague application or was about to file a Hague application. And the Canadian court enters a temporary order and a final order on affidavits alone. It doesn't confer with the Henderson County Court, and it purports to grant sole custody to Ms. McDowell. It's these orders that she's trying to register here today, and she tried to register at a hearing in Wake County. And the trial judge in Wake County correctly denied confirmation of those orders because it found that Canada didn't have jurisdiction under the simultaneous proceedings provision of UCCJEA, which is 58-206. And that brings me to my first argument, that Canada lacked jurisdiction to enter a custody order because there's already a pending action in North Carolina. I think both parties on appeal agree that the threshold question is there a pending proceeding in another state? In fact, the record on page 99 is a flow chart that's in the bench book that we give all of our family court judges in North Carolina. And it asks that very same question as the preliminary question in the flow chart. And the gist of 58-206, which is what that question is addressing, is that a court can't exercise jurisdiction if at the time of the commencement of the proceeding, there's a proceeding concerning custody of the child that's already been commenced in a court of another state having jurisdiction substantially conformity with the UCCJEA. And so the analysis that Judge Worley in Wake County had to consider in this would be where you basically have to swap North Carolina and Canada when you're reading that statute. And basically the statute would read, except when exercising temporary emergency jurisdiction under 204, Canada may not exercise jurisdiction under this if at the commencement of the proceeding, a proceeding concerning the child has been commenced in North Carolina, unless that proceeding has been terminated or stayed by North Carolina. And counsel for Ms. McDowell has conceded that North Carolina has never terminated or stayed that proceeding. And so,
Mr. Russell, what impact, if any, does the fact that the Henderson County custody proceeding has been dormant for quite some time subsequent to the January 2013 entry of the ex parte order, what impact if any, does that have on our consideration, the fact that it's been dormant for a while?
Your Honor, I would argue that it has no impact. The counsel for Ms. McDowell cited to Woodring for the proposition that that order could have become permanent by operation of time. It's interesting, Chief Judge Martin, the Court of Appeals, wrote Woodring. I was working at Chief Judge Martin's chambers when that case was written and worked on that case. And Woodring specifically talks about how when you have an order that only lays out a specific amount of visitation or doesn't give one parent visitation, that operation of time or operation of law shouldn't remove custody from one parent, because we have a standard that says in custody cases that if you're going to not award any kind of custody to a parent, you have to find that they're unfit. You have specific findings there, and this order doesn't have that. It doesn't give any custody to Ms. McDowell, and it specifically asks that there be a return hearing like any ex parte order would. I think there's sort of been a fundamental misunderstanding of how an ex parte emergency custody order happens in this state. It's not something that you would ever not have a return hearing on, because it's designed to deal with an emergency that's authorized by 50-13.5. It's a temporary order. We would always have a return hearing because generally you're giving custody to one parent to figure out what this emergency is and whether emergency situations still exist. And Ms. McDowell should know that. She applied for an emergency order that was and got an ex parte order in September of 2011, had a return hearing in November of 2011, and the emergency was dissolved because she failed to prove any of the circumstances that would require an emergency order to be entered. So I think that the lens that we're looking through some of this actions through, Ms. McDowell's counsel says that they're not UCCJ cases, whether it's Woodring or any other cases, but I think they're instructive. Ms. McDowell's counsel raises the issue that it's a final order in her brief. And so I think we have to look at our cases in North Carolina because there's nothing directly on point about what's a temporary order and what's a permanent order. And while Woodring was specifically dealing with whether it's a temporary order or a permanent order in order to decide what the standard would be to modify that order, I think the framework there is helpful and instructive to this court to determine whether something is still pending. A permanent order would mean that there's nothing pending in the case unless a motion is filed. A temporary order would mean that there's still an action pending, and that's exactly what an ex parte custody order is. It's a temporary order. We have the Camp v. Featherstone case says that. If you look at the bench book that Cheryl Howell has authored, it says that basically an emergency custody order is just another form of a temporary order. It's a special form of temporary order that requires a return hearing to resolve that emergency. And
Mr. Russell, can an ex parte order ever be a final order?
I don't believe so. I don't believe so, Your Honor. Unless it was a very specific emergency ex parte order that laid out custody for both parents that was never challenged. But almost in my practice, almost every single ex parte emergency order that's entered gives sole custody to one parent. It's usually that there's, because of the standard that it's required to get an ex parte emergency custody, you need to say that the child's life is in danger, or that the child is in danger of sexual abuse, or that someone's going to abscond with the child to another jurisdiction. Those are the narrow ways in which you can get an ex parte emergency order. So it's not likely that if you find that those things exist, that you're going to set out a schedule that allows both parents to continue operating a custody schedule. And so I don't believe it ever would become a permanent operation of time unless it was a very unusual ex parte order.
Well, where I come from, ex parte orders are obtained without notice to the other party or the other party's counsel, if they have counsel, or you suspect that they have counsel. I don't know if that's the same in Henderson, but if you have no notice, can that ever be a permanent order or a final order if you've not had notice of that ex parte hearing before it occurs?
I wouldn't think so, Your Honor. I think that would be violative of due process of the other party. I mean, the idea of the ex parte order is that we're dealing with a very exigent circumstance, but we have to get back for a return hearing to sort those things out. And, you know, I think it depends on local rules in a particular county as to how notice is done. In Wake County, you know, if someone's represented, you have to give 2 hours notice that you're seeking an ex parte order. I don't know the local rules in Henderson County, but you know, generally speaking, it's not something, and by its very nature, the name, it's ex parte. It's one party that's there seeking this action. It's rare that somebody shows up and gets to argue the other side. And it would be something that I don't see how it would become permanent by operation time or any other way. I think, Your Honors, Ms. McDowell talks about this order being a final order in her brief, and says that there's nothing else to be judicially determined because basically custody was an issue and this ex parte order grants custody to Dr. Buchman. So there's nothing else to be determined. And I think that's a misapprehension of how ex parte orders work. I think it's something that if you look at the plain language of the ex parte order, there's a lot to be judicially determined. It says it's pending a hearing on the merits, and it says that it doesn't deal with legal custody. It doesn't give Ms. McDowell any custody. And so there are a number of issues that need to be judicially determined before that order could ever become final. I think that Ms. McDowell in her brief and also to this court earlier mentioned that neither the Henderson County District Court nor Dr. Buchman have taken any action to conduct a hearing or further proceeding with respect to this order in the 6 or so years since its entry. And that somehow makes this a final order. I think that sort of conveniently overlooks the fact that the only reason that hasn't happened is that Ms. McDowell is no longer in North Carolina. She's fled the jurisdiction in Canada. I think Henderson County certainly has an interest in hearing this case again. I think a couple of things demonstrate that interest. One, McDowell on her Twitter feed posted some correspondence between the district attorney in Henderson County, Greg Newman, and her Canadian attorney, where the district attorney asked that Ms. McDowell's Canadian attorney please ask her to stop calling and writing his office and suggest that she get a North Carolina attorney so that she can deal with the criminal matter that's down here. And the district attorney also mentions in that correspondence that there are going to be proceedings in the district court on the custody order. And that correspondence is on page 98 of the record, Your Honors. I think the other thing that demonstrates Henderson County's interest in conducting future hearings in this is the denial in Henderson County Superior Court of Ms. McDowell's motion to dismiss the criminal charges by a Henderson County judge. So I believe, you know, for all those reasons under 58-206, there was a pending order or pending proceeding in North Carolina that would mean that Canada does not have jurisdiction to enter a custody order. And Judge Worley got it correct when she decided that the custody order should not be registered here in North Carolina. My second argument about why the trial court correctly ruled here would be Ms. McDowell's unjustifiable conduct. There's a section in UCCJEA they call it clean hands provision, and it's designed to prevent form shopping, and it's designed to prevent basically the exact conduct that Ms. McDowell engaged in. And it says if a court has jurisdiction over this article because a person seeking to invoke jurisdiction engaged in unjustifiable conduct, the court shall decline to exercise jurisdiction. And the uniform comment talks about how this section is designed to ensure that abducting parents don't receive an advantage for their unjustifiable conduct. And I believe that's exactly what Ms. McDowell's done here. She's engaged in unjustifiable conduct. She abducted a minor child, fled to Canada while there's an action pending in North Carolina. She had a full opportunity over 4 days in North Carolina before a judge who had the benefit of hearing from all witnesses, experts on both sides of the case, and a guardian ad litem who presumably had interviewed the child and the parents. And by contrast, the Canadian court took no live testimony. The Canadian court even determined that Dr. Buchman's use of the exact statutory procedure that our statutes require someone to use in this situation, the ex parte order, was somehow bad faith on his part. How they found bad faith in him doing exactly what our statutes and what any family law attorney would advise him to do, to seek an ex parte emergency custody order, just shows how inappropriate and misguided the commitment process was. And I would direct your honors to the fact that her sort of unjustifiable conduct continues to this day. She's regularly attacking the district attorney, Greg Newman, the trial judge, who's now chief district court judge in Henderson County, Mac Bredden, Dr. Buchman, Dr. Buchman's wife, who's also a doctor, on a Twitter account. And some excerpts of her Twitter account are in the record on pages 93 and 98. This is someone who's not engaging in a clean hands or an equitable way. I think there's an equitable argument to be made that basically she's now before this court asking to register a foreign order when she chose not to invoke the jurisdiction of this appellate court when she got a result she didn't like in Henderson County in 2012. She absolutely could have filed post-trial motions. She could have filed a notice of appeal and deal with the result she didn't like in 2012 that way. Instead, she did the one thing that we don't want clients to do or litigants to do, and that's abscond with the jurisdiction. The only thing that she could have done, quite frankly, is under Ramirez-Barker, file a motion to modify and ask permission from the trial court to relocate. And in that case, it would be an actual relocation, not absconding with the child. But you have to satisfy the trial court that she has reason to relocate to Canada. And she didn't do any of those things. Instead, she absconded the jurisdiction, hid for a number of years, and I think it would offend public policy for her to be able to behave in that way, not like the results she gets after a 4-day trial, and hide out for a sufficient amount of time, and then invoke the jurisdiction of a foreign country and relitigate issues that she lost at the first trial, which would be res judicata in our courts, and be allowed to register that order here. If she had moved from Henderson County to Orange County, which she did, but if she tried to invoke the jurisdiction of the Orange County court, she would have been allowed to relitigate any of these issues. She would have been allowed to bring these allegations in front of the Orange County court. It would have been res judicata. So I just don't think you can, your honors, reward this kind of conduct. I mean, as someone who practices family court on a regular basis, the concept that if the litigant doesn't like a result, they can go to another jurisdiction and get a second bite at the apple it's a little difficult and unsettling to deal with. So I would ask your honors not to countenance that behavior on her part. Let me address some specific issues that Ms. McDowell's raised in either her brief or her argument here today. One of them is that suggesting we're swapping horses to get a better mount. That's a phrase that describes taking one position at the trial court and a contrary position on appeal. And I would argue, your honors, we've consistently contended that the ex parte order was pending and temporary in all of these proceedings. If you look at the transcript on page 23, lines 11 through 15, my co-counsel, Mr. Horwitz, who argued this case at the trial level, talks about matters still pending and how it was pending because it didn't establish an ongoing visitation schedule for Ms. McDowell. The same argument that we're making about how under Woodring, if it doesn't establish an ongoing schedule, that it's got to be a temporary order that's pending. I just don't believe that how Dr. Buchman chose to refer to a final order or refer to this order as a final order in a Hague application prior to the trial, it was the same thing as making that representation or taking that position at the trial court. I mean, first of all, you have a layperson who's filling out an application to try to see his son again. And, you know, I think how a layperson describes the order in the application is not something that's binding on that person. In fact, I think Woodring and several other cases stand for the proposition that even what the trial judge labels an order isn't binding on the appellate court in terms of whether an order is temporary or an order is permanent. They look at the process to see whether it's without prejudice to either party, whether it sets a clear reconvening date, or, and these are ors, doesn't determine all the issues, and that's what happened in this case. The order did not determine all the issues. It left open many things to be decided, which is why it's a temporary order. The other issue that's been raised is an issue about evidence, and I think let's be clear. The hearing before Judge Worley wasn't an evidentiary hearing. Nothing was offered into evidence. Neither party moved anything into evidence. Judge Worley heard legal arguments from Ms. McDowell's counsel first, and as is customary in Wake County, she handed up the same exhibit notebook, which Ms. McDowell's counsel refers to as a loose binder of exhibits. That's kind of how we do things here. She handed that same sort of notebook up to the judge, made a legal argument, referred to documents that are now in the record on appeal, and we did the same thing. And in her brief, Ms. McDowell refers to there only being one thing that's sort of admissible evidence, and that's the affidavit of her attorney in Canada. And I'm a little confused as to how that would be admissible in a full-on evidentiary hearing. I mean, the affidavit's hearsay, and there's no exception to get it in under 803 or 804. And this wasn't a summary judgment proceeding where you're taking affidavits and using that to decide the issue. So I think to refer to that as the only admissible evidence sort of misses the mark. I think that all of the custody orders in the case are certainly admissible. I think that the trial judge can take judicial notice of any of the pleadings. I think that's all that the trial judge needed to look at. All the judge really needed to look at was the fact that in the record, I believe starting on page 4, maybe page 3, is the 2012 order, and then following that, the ex parte order that was there to understand the procedure and what had happened in the case in North Carolina, to understand that something is still pending. So I think the only evidence that Judge Worley needed was right there in the record, something she could take judicial notice of. So I believe, Your Honors, that if Judge Worley wanted to hear evidence, she could have. Dr. Buchman was there in the trial court. If she wanted to hear from him, she could have. Obviously, Ms. McDowell was not there, presumably because she was arrested if she had showed up in North Carolina. And so I think this idea that there wasn't evidence for the judge to understand or rule on this issue, I think is wrong, because this is a legal argument. I think that brings me to my final point, Your Honors, which is that emergency jurisdiction for the Canadian court to proceed on either. And I know that counsel doesn't, or Ms. McDowell doesn't claim that there was emergency jurisdiction, but it's important to see that Judge Worley said that was not a basis that they were exercising jurisdiction. And that's true, because the Canadian court was exercising custody under the emergency jurisdiction prong. It's 58-204 of the UCCJEA. And then it would have been a temporary order that was entered up there that gave Ms. McDowell time to come back to North Carolina and seek an order here that dealt with whatever issue she was having up there. And the other thing that 204 would require is that the Canadian court communicate with the North Carolina court, which it never did. And quite frankly, I think if the Canadian court had, that the North Carolina court would have made it aware that it saw this issue rather differently than Ms. McDowell was presenting it in Canada. And so the Canadian court didn't have jurisdiction under 206. The Canadian court should have declined to exercise jurisdiction under 208 because of her conduct. And the Canadian court didn't have jurisdiction under 204. And so for those reasons, I think the trial court correctly got this case or correctly ruled in this matter, and this court should affirm the trial court's ruling, which correctly denied confirmation of registration in North Carolina of the Canadian order because it was not entering compliance with the UCCJEA. Thank you, Your Honors.
Thank you, Mr. Russell. Judge Berger, do you have any further questions?
No, thank you.
Okay, Judge Brooks, do you have any further questions?
No, thank you.
Thank you. Ms. Holcomb, Ms. Holcomb, and where I come from, it's Holcomb. Have you heard that before?
Your Honor.
Ms. Holcomb, you may proceed with your rebuttal.
Thank you, Your Honor. Just briefly, I want to start with the argument that appellee's counsel raised that because Ms. McDowell has never returned to Henderson County, it is impossible for either the Henderson County Court or Dr. Buchman to finalize the order that he now argues is temporary. Since Dr. Buchman was served on multiple occasions with the pleadings in the Toronto court, his first service date was May 20th, 2015. Since May 20th, 2015, Dr. Buchman and his counsel have known how to serve Ms. McDowell. They've had her home address, they've had contact information for her attorney, and they could have served her to set a final hearing and proceeded without her if she did not appear. That has not happened, neither since the order was entered in 2013, nor since he initially got that notice in 2015. And it's been 5 years since that point. So this idea that it was impossible to proceed unless she physically returned to Henderson County is simply not supported, either in the law or in the record. Addressing unjustifiable conduct. If you look to the statute, section 208, appellee's counsel is correct that it does require a court of this state to decline to exercise jurisdiction when the party seeking to invoke jurisdiction has engaged in unjustifiable conduct. However, it does provide exceptions to that requirement. The third exception is set out in 208A3, which provides that the court at which the party moving that they're seeking to exercise jurisdiction doesn't have to decline jurisdiction where no court of any other state would have jurisdiction under the criteria specified in 201 through 203 of the UCCJEA. Section 201 is home state jurisdiction, essentially. And as we've talked about here today, the parties relevant to that determination, meaning the minor child, had resided in Canada for 2.5 years at the time that Ms. McDowell sought to invoke the jurisdiction of the Canadian court. So 201 does not confer jurisdiction on North Carolina. Section 202 is continuing and exclusive. And under the continuing and exclusive jurisdiction provision of the UCCJEA, North Carolina no longer had continuing and exclusive jurisdiction because no parties resided in North Carolina, a determination that Canada made in 2015 when Ms. McDowell applied for it to invoke its jurisdiction. And Section 203 is modification jurisdiction. And for the same reasons, Section 203 doesn't apply to North Carolina. So because even if you accept the argument that Ms. McDowell acted unjustifiably, which we do not, the plain language of the statute provides that Canada was not required to decline to exercise its jurisdiction in this case. Speaking to public policy, appellee's counsel argues that public policy would in some way require that the court not allow Ms. McDowell to register her order here. The public policy of the UCCJEA can be found in the official comment to it. And the official comment to the UCCJEA, and specifically Section 208 on unjustifiable conduct, provides that where a party is fleeing domestic violence or trying to protect another party from domestic violence, you cannot automatically dismiss an action under Section 208. We would argue that that applies here. And I see that I am running low on time. I will say that under the official comment and the public policy, the court's job is to determine whether that conduct of fleeing the jurisdiction was justified in this case. And the court made several findings of fact that are relevant to that determination and found that abuse had occurred and that the child was exhibiting behavioral symptoms associated with abuse. And we would ask that the court reverse and remand with instructions to register the Toronto Court's order.
Thank you. Judge Berger, do you have any further questions?
No, thank you.
Judge Brooke, do you have any further questions?
No, thank you, Judge Zachary.
Mm-hmm. Thank you, Ms. Holcomb.
Thank you, Your Honors.
That concludes oral argument in this matter. I want to thank you, all counsel, for your participation and your excellent arguments today. Mr. Horn, we may adjourn.
This session of the North Carolina Court of Appeals is now adjourned.
Thank you.
Thank you, Your Honor.
Thank you.